Jim, Alabama yields back. I'll go last. Ms. Nguyen, I'm one of those too many lawyers my colleagues make reference to from time to time. I'm not a subject matter expert here or anywhere else, but I suspect lots of people that are following this issue and maybe that are watching the hearing aren't subject matter experts either. So I get that all of you are experts and the vernacular just rolls off your tongue, but for lots of people, they don't know what a midnight regulation is, they don't know what the CRA is, they don't know what a guidance document is. So with specific reference to midnight regulations, how, if at all, does it impact the CRA?
The midnight rulemaking is defined by the mandate that, in terms of our review, it's defined by a specific period between September 23rd and January 20th. So we were mandated to look at the midnight rulemaking. It's referred to that because of that period. And in terms of the CRA, as I noted, we found that compliance with CRA for the transition period, in comparison to non-transition period, they're about the same. The trend that's important to note is that compliance with CRA has increased over time.
Can you tell us which agencies had the highest rate of non-compliance?
The two agencies that have the highest rate of non-compliance are HHS and DOT, and EPA has the lowest non-compliance rate.
What justification or explanation were offered by the two with the highest rate of non-compliance?
Because of the breadth and scope of our work, we were asked to look at non-compliance, the compliance with midnight rulemaking over the course of 20 years for various procedural requirements. So therefore, we did not have the opportunity to inquire with those agencies.
If I may add, we are taking steps to notify those agencies of their noncompliance, to call to their attention their obligations under the Congressional Review Act.
So you think it's a matter of oversight rather than intentionality?
I wouldn't want to speculate on that. I don't know. We haven't looked at that question.
Is there a correlation between non-compliance and economically significant regulations?
Our study shows that economically significant regulations have a non-compliance rate of about 25% and 15% for significant rules.
All right. For those who have never heard the term before, what is a guidance document?
Guidance are used by agencies to provide timely information to agencies, and agencies also use them to convey how they plan to interpret regulations. Guidance, generally, they're not legally binding.
Whenever you use words like generally, it makes me wonder that there's an exception to that.
The exception is what we discussed earlier with the notion that the IRS views their guidance to be authoritative.
If I heard Professor Perillo correctly, there's no legal force, lay the IRS aside, there's no legal force attached to guidance documents. Are there any legal presumptions attached to it, accepting that it doesn't have force of law? Are there certain presumptions attached to guidance documents?
I cannot speak about the presumption issue. That's really from the perspective of the regulated parties.
Can I ask your lawyer, is there a legal presumption attached in any way with guidance documents? Here's what's vexing me when I hear the professor say, and I'm sure he's right, that it's not intended to have the force of law or for everyone to conform their conduct, that they still want to go on a case-by-case basis. Whenever I hear the phrase case-by-case, that's just Latin for no guidance. There's no uniformity. If you're going to go case-by-case, which is what I think I understood him to say, then what is the purpose and/or legal effect of guidance documents?
I believe that guidance documents, by definition, are not legally binding on the regulated community. There have been complaints over the years, however, from the regulated community that at times agencies are imposing binding requirements on the regulated community through guidance rather than going through a rulemaking procedure. And I think that's the underlying complaint behind the use of guidance, not where it's used for the purposes for which it's intended, but rather to impose binding requirements that should really be going through a rulemaking process.
Will the gentleman yield for a follow-up question to your point?
Certainly.
The chairman is spot on, and he's in a line of questioning that, quite frankly, is at the very heart of this hearing. Is guidance typically, and where he's going with this is, does it have any other meaningful effect, either through previous jurisprudence or lawsuits where guidance has been used in a way that is connotates a rule or a regulation instead of just guidance? And
I think it would be fair to say that there have been complaints that guidance has been used to impose requirements that should not have been imposed unless they went through a rulemaking process.
Yield back. Thank you, Mr. Chairman.
Well, let me ask one other question. Is there a colorable claim or cause of action if the assertion is that this discretion referenced by Professor Perillo was applied disparately to this group versus that group? Is that a cause of action? Is that a colorable claim from a litigation standpoint that this exercise of discretion was used disparately?
I think actually Professor Perillo might be best qualified to answer that question.
I'm sure he's written a law review article on it. He may direct us to it.
On the question of whether, as I understand your question, whether inconsistency between individual cases would be subject to a judicial challenge, if the context were enforcement, then no, because under Heckler versus Cheney, at least one-off enforcement decisions or decisions not to enforce or to enforce in the first place are not subject to judicial review. If we move beyond the context of enforcement and we talk about agency adjudication, such as permitting or something like that, then if an agency does not follow the reasoning that it used for a prior individual decision and gives no explanation of why it didn't follow that reasoning, then that would be subject to a judicial challenge. So it varies by the type of individual proceeding we're talking about.
Thank you, gentlemen.